All right, so we'll go ahead and get started here, and let me just pull up the PowerPoint again. All right, so I'm Kevin Hirzel. I'm the managing member here of Hirzel Law. So this is a class that I teach every year. It's really geared towards new board members to kind of give you the basics and the fundamentals of the stuff that you need to know, get you accustomed to regular things that you're going to be dealing with throughout the year. So, like I said, feel free to go ahead and ask questions in the chat. I will do my best to answer them as we go along, and we'll make sure I save a little bit of time to open it up and open up everybody's mics at the end to go over everything. So welcome so you joined the Community Association Board, now what? And so just to kind of give you an overview of what we plan on covering today, we're going to go over the types of community associations, the governing documents, how to handle meetings, bylaw enforcement and collection, and then a little bonus at the end that I call Hirzel's Hurtful Mistakes to Avoid, which are some common errors that I see people fall into, just due to ignorance and to try and help you avoid those kinds of mistakes. So the first thing we're going to cover is the different types of community associations and what a community association is. And so it's really a combination of, several factors. So, first off, most of them are going to be organized as nonprofit corporations. And to some extent, they kind of serve a role as a mini government. And so you have rules and regulations, bylaws, and you're charged with enforcing those to make the organization run. The second component of it, I always tell people, is the actual real estate itself. And so obviously this is an investment for most people. You're concerned about maintaining your property values. And for most people, it's their biggest investment. And then the third component of this is that we all have to be neighbors. So you guys are a society, and trying to get everybody to get along while following the rules and maintaining the property values is really kind of the key. So these are the three components of pretty much any kind of community association, and keep that in mind when you're operating it. In Michigan, we have 4 different types of community associations. So we have condominiums. So a lot of those can be your traditional attached condominiums. We also have something called a site condominium. And a site condominium is single family homes. It may look like a homeowners association or a subdivision, but it's really organized as a condominium under the Condominium Act. We have your traditional homeowners associations. Michigan's a little bit unique in that we do not have a specific homeowners association act. A lot of the homeowners associations are nonprofit corporations, so they're subject to that particular act. But for the most part, a traditional homeowners association in Michigan is going to be governed as a matter of contract based on the governing documents. The third type of association we have is a co-op. So there's not a ton of these, but this is a unique type of association where the owners don't actually own real estate. What they own is a share in a corporation, and that corporation owns the real estate. The fourth type that we have is a summer resort, and this is something that truly is unique to Michigan. There's 5 different acts. They're all from the late 1800s, early 1900s. There's a few hundred of these. A lot of them are in western or northern Michigan, but they have some very nuanced and specific rules, and in fact are often treated as quasi-governmental entities. So those are the 4 different types of community associations that we have in Michigan, and my guess is that each one of you is going to fall into one of these types. Most people are going to fall within the condo or the HOA world. So as far as the different governing documents, this is really going to be kind of the key component of what you should be aware of. And before we kind of get into that, I always like to go over what the relationship is between the governing documents and the actual law. So under the Supremacy Clause for the United States Constitution, federal law is always going to trump. And so there's certain federal laws that you're going to encounter as far as the Fair Housing Act, things of that nature. There's the OTARD rules, the FCC rules on satellite dishes, and several other things that may pop up. So those are pretty much always going to trump no matter what you're doing. The next thing, that's going to fall below that on the hierarchy is going to be state law. And so we have the Michigan Condominium Act, the Michigan Nonprofit Corporation Act. We have our own civil rights statutes, and anti-discrimination laws. And so that's going to fall next in the pecking order. Third is going to be municipal law, and oftentimes, these will work in conjunction with the documents and not conflict. But generally speaking, your documents, you just need to make sure that they comply with federal and state law. It's usually fairly rare that a municipality is going to have requirements that are going to, I guess, conflict or dictate what's going to be in the documents. Oftentimes, though, documents will have provisions that indicate that you can't do something illegal, and if somebody's violating the zoning ordinance, you may be able to, enforce that under your documents that way. The third component is going to be the articles of incorporation in the recorded documents. So if you are in a condominium, that's going to be the master deed and condominium bylaws. If you're in a homeowners association, that's going to be deed restrictions. Sometimes it's called the declaration, restrictive covenants, things of that nature. And then you'll have unrecorded corporate bylaws that go with that. If you are in a condominium, you're going to have typically the bylaws will be part of the condominium bylaws. And then the last component on this is going to be rules and regulations. And so typically most documents will give the board authority to enact rules and regulations. And those rules and regulations, they have to be consistent with the governing documents themselves as well. So keep that in mind. With respect to the document that is really kind of the driver that creates the corporate entity, that's called the Articles of Incorporation. And typically in Michigan, 95% of community associations are going to be organized as nonprofit corporations. It is possible to have an unincorporated association. If you are, you probably want to explore incorporating for liability purposes and protection if you're going to serve on the board. There's certain benefits that we're going to go over a little bit later on in the presentation that you get from being an incorporated association. So keep that in mind. Most associations are going to be organized as a membership association. And that means that the members will have certain voting rights. And that's typically related to the election of directors and amending governing documents. There are a few associations that I've seen that are organized on a director basis, which basically means that the directors are going to dictate everything and make all the determinations, and they're going to appoint and elect the directors. It's possible to have that in Michigan. A lot of those are going to be nonprofits that don't have members, so charities and things like that. So I have seen a few times that community associations have been organized as a directorship basis on accident. So you want to take a look at your documents to make sure that it has some sort of reference to membership. The other component here is that most associations are going to be mandatory. That means there's some kind of recorded document that runs with the land, whether it's the master deed, the condominium bylaws, declaration, anything of the like that says that somebody is required to be a member of this association and follow these rules. We have seen, a few times that you can have a voluntary association. That means there may be a set of about 10, 15 restrictions, something like that, that's recorded. There was not an HOA that was formed as part of the initial formation of the community, and then they needed an association to operate things moving forward. Those are going to be typically a lot more difficult to operate. And I think there was a joke at the beginning of the call about whether somebody can come and go in an association. And that would be true in a voluntary association. And oftentimes it's difficult to collect assessments and actually run the thing. So if you're not aware of where your articles of incorporation are, they are on a state website. I put the link up here. You could also get to it by Googling Laura. They'll have an entity search, and you can put the name of your association in, and you should be able to find your articles of incorporation to get a sense of what's in them. And I'd encourage you to review those. The other thing that corporations are required to do is there's going to be annual reports that have to be filed. So traditionally, under state law, so for Laura, you have to file an annual report with the state of Michigan to say that you still exist as a nonprofit corporation each year. Under the Nonprofit Corporation Act, if you have not filed that for the last 3 years, you automatically get dissolved. It's not terribly difficult to reinstate, but it is important to do that if you have been automatically dissolved. And traditionally, this hasn't been a big deal. The corporation gets reinstated, you move forward. you'd have to pay $25 a year for each report and pay a $5 late filing fee. And so this is something, that's always existed and to be aware of and to make sure that you're filing an annual report in each year. It's typically in October when that gets filed. And that's going to go to whoever is designated as the resident agent for the association. The new thing that everybody should be aware of starting next year is the Corporate Transparency Act. So this is something that's going to be new. It's starting in 2024. It's something that has been created by the federal government. And so there's a federal agency called FinCEN, and they are going to be charged with collecting certain information related to every corporate entity in the United States. And so since nonprofit corporations are a form of corporate entity, they are not exempt from the act. And typically there's certain information related to the corporate entity that's going to need to be filed starting next year, as well as to the people in control of a corporation. So with respect to the actual association itself, they're going to be collecting information as to the name of the entity, if it has any other DBAs, its address, the jurisdiction where it's formed, which is typically going to be the state of incorporation, and the tax ID. So that information will need to be provided to the federal government. And then the other thing that is going to be important is that board members, as they are the ones that are going to be in control of the nonprofit corporation, are going to have to provide some information. So they're going to require the name of each board member, their date of birth, address, a unique ID, which is typically going to come from a driver's license, passport, that kind of thing, and an image of those ID documents. And so if you don't do that, by the end of next year, there's going to be a $500 a day fine, up to $10,000, and potentially up to 2 years in prison for that. The other thing about implementing this is it's a little bit different than the annual reports, is that whenever there's any kind of change on the board, they're going to require a real-time update on that, as opposed to the annual reports everybody has been used to filing with Laura, that really only have to happen once a year. And given that these are fairly steep penalties, this is something we're really going to be encouraging our clients, to start, getting in compliance with at the beginning of next year, and not waiting until the end of next year. So you're kind of ahead of the curve on that one. And that's something that we're prepared and we're implementing a process to be able to collect all that information securely if board members don't want to share it with each other, and file that and make sure that it's done correctly, given the potentially hefty penalties attached with that. So like anything that's new, my guess is there's probably going to be hiccups in the system, and they have their own online filing system. But it's definitely something to be aware of going into next year, as that will be a new change in the law. So in addition to the annual filings, let's see. So I did get a question. Is that something that you as a law firm does, or through the management company, or we do it ourselves for Laura and the CTA? So us as the law firm, we can do both of them, and some associations come to us and ask us to do that. So we can certainly offer that. I'm not aware of management companies doing, I guess, CTA compliance. Some of them will do the annual reports, though, depending on the management company, and certainly self-managed boards, they would still be responsible for complying with this. Some of them, comply with Laura. You could, as a self-managed board, comply with the CTA, as long as you are comfortable, with the board members all exchanging the information that's there, and, confident that you can, complete the form, successfully upload the report, and that kind of thing. So, that can happen either through the attorney, the management company, or the board, whatever you're most comfortable with. But I would say, at least with us, everything's going to be kept on an encrypted server, and we're going to make sure that it's secure when the information is uploaded. That whoever's gathering the information, that they keep it safe, especially with the license, the passport, and that kind of thing. So for the articles of incorporation, just to kind of give you a heads up as to what you're looking for and what you should see there. The corporate purpose needs to be stated, which is typically that you're there to operate an association for a certain subdivision or condominium. Defining who members are, and sometimes, who's going to be subject to the bylaws, who's responsible for paying dues, who's get notices, that's going to be important in typically defining whether somebody who is buying or selling on land contract, who's the member in that situation, is important, and you'll want to make sure that you have there. And we've seen that become an important thing for enforcing the bylaws, collecting assessments, that kind of thing. We're going to get into the limitation of director and officer liability. And so what's the standard of care that's going to be defined by this document? Whether directors and officers and volunteers are going to be indemnified and under what circumstances. And the other thing you typically will see here is whether you as the association can hold a vote and outside of a meeting, or whether or not you need to actually vote within a meeting. Let's see, we have a question here. How does one know who is an actual owner with a land contract? So typically, I mean, the actual owner is going to be the person who is selling that. And the person who's buying it, they have what they call equitable title, and they don't have fee simple title until that purchase is actually completed and a deed is conveyed. But certainly some documents are going to indicate that both are going to be responsible, for anything that a member would be, whether it's assessments, complying with the bylaws, that type of thing. And so typically, that's why we recommend that it would be specifically designated in the articles of incorporation, so there's no confusion there. So, all right, kind of taking a look at why it's important to have director liability taken care of in these documents. I'm going to run through a quick scenario for you, and if people want to maybe give me some answers in the chat, I'll tell you how this would turn out. So we have Joe. He's the president of Electoral Acres Association. The bylaws require the association to have 100% replacement cost for property insurance. Association's insurance agent advised Joe that the current insurance policy does not cover 100% replacement cost as required by the bylaws. Joe and the rest of the board forget what the insurance agent said and vote to maintain the current insurance policy because it's cheaper. Fire burns down the condominium building. Insurance policy limits $1 million. The cost to rebuild is now $2 million. Is Joe liable for the $1 million? Well, does anybody have any guesses that they want to put into the chat here? All right, hope not. No. So in this one, I think there's a pretty decent chance that Joe probably would be liable. And the reason in that circumstance is that there was a specific requirement in the documents. He went to a professional, he got advice, and he ignored the advice of the professional. So with respect to liability under the Nonprofit Corporation Act, if you rely on the advice of a professional, if Joe had followed the insurance agent's advice and the insurance agent maybe had told him something wrong, he would have liability protection, and there's something called the business judgment rule. So a director officer, they're not entitled to rely on information if they know that reliance is unwarranted, or that somebody is telling them that's blatantly false. But certainly if you are relying on an accountant, an engineer, attorney, anything of the like, that is going to bring you within the protection that even if you make a mistake, if you're following that advice, that you cannot be held personally liable for it. But if you're acting outside of the documents and you're not relying on advice or ignoring advice, that's when those liability protections go away. With respect to limitations on liability themselves, that's going to kind of depend on what you have in the documents. And so the Articles of Incorporation under a Nonprofit Corporation Act, they can eliminate director and officer liability for money damages or any failure to take action except for the following circumstances. And so a financial benefit. So if you went to the bank account and stole money that you were not entitled to, an example of this is, that hammocks case that keeps evolving down in Florida, where there was a lot of financial abuse there from the board members. They would not be protected and would be held personally liable. If you're intentionally inflicting harm to the corporation, if there's an intentional criminal act, or any liability imposed under Section 497A of the Act, which is basically attorney's fees and cost in a failed derivative action. But where this typically comes into play is whether the board members, you can eliminate liability for ordinary negligence, you could eliminate liability for gross negligence, essentially for pretty much anything other than stealing. And so this is going to be helpful for a lot of associations, just because the cost of insurance keeps rising, D&O insurance keeps going up across the country. And so if you have these types of protections, it will help eliminate claims and help people feel a little bit more comfortable about serving on board. So some associations decide that they don't necessarily want to give those liability protections. We typically recommend that you do. So you're not required to have them, but that will certainly, like I said, make people feel more uncomfortable on serving on boards and be better probably for your insurance loss runs. For the types of insurance here, just to kind of give everybody a heads up, we're primarily going to be talking about directors and officers insurance today, because this is about board members. But the other ones you want to make sure that you have and at least have some familiarity, or talk to your insurance agent or property managers, that you're going to have a general liability policy. So if somebody gets hurt, there's property damage, something like that, that you have a property damage policy. D&O, crime insurance. So, if somebody, a property manager runs off with $100,000 out of your account, or a board member, or something like that, that you'll be able to get reimbursed through the crime insurance policy. That's also something that Fannie Mae and Freddie Mac look at for financing purposes, for the sale of condos. So it's important to have for that reason. Cyber insurance, and this is something I'm seeing a lot more, where somebody may pretend to be a board member and send a fake email to another board member and tell them to pay a bill or something alike. And then typically workers' comp, if you have any employees, but also if you have any volunteers performing any type of work and they could potentially get injured, it's helpful to have that policy as well. So that's kind of a quick checklist on the insurance front. For the directors and officers end, as well as pretty much any other insurance policy, you should be aware that there are two types of protections and two different things. One is the duty to defend, so that if you get sued, the association gets sued, the insurance company should appoint an attorney and pay for that attorney. The duty to defend is extremely broad. And so if anything arguably falls within coverage, they're required to defend that and provide you a defense. Most times that will be under a reservation of rights, and that is the right to challenge whether they have to indemnify you at the end. So the second duty is the duty to indemnify. So what that means is that if there's some kind of a judgment, some money needs to get paid out at the end, it actually has to be something that's covered by the policy. It can't be arguably covered by the policy. And so what they're really looking for is the ultimate liability at the end of this case. Is that something that's covered by the insurance policy? So it's certainly something to be aware of. With respect to director liability, I'm going to give you another scenario and kind of give you a heads up as to what you may want to be looking for in your D&O policies, because they're not all the same. So we have Jim. He serves on the Electoral Acres Board with Joe. Jim claims Joe did not tell them the insurance agent recommended better insurance, that Joe misrepresented the insurance requirements in the bylaws. Joe tells Jim he was never validly elected at the last election because he did not have enough votes. Jim sues Joe for the $1 million for breach of fiduciary duty. Joe sues Jim to have him removed from the board. What claims are covered by D&O? So anybody have any guesses as to whether Jim's claim for Joe for the $1 million is going to be covered under D&O insurance because he screwed up, or Joe his claim for Jim is going to be covered, saying that he was not validly elected to the board? Feel free to put any guesses you may have into the chat. Okay. It's like Jim's claim, breach of fiduciary duty case. So you certainly want to have D&O for the breach of fiduciary duty claims. But the answer is it depends on what kind of insurance you have here. So it's certainly possible that neither of these claims could be covered depending on the language of the insurance policy, or it's certainly possible that both. So typically what D&O is going to cover is the adoption of rules, architectural control decisions, assessment decisions, breach of fiduciary duty, as was indicated in the chat, defamation, election disputes, failing to enforce bylaws. Those are kind of the common things that a director or an officer may get sued for. Where it gets a little bit tricky is the exceptions. And so a lot of times people will try and save money and they will buy a package policy, and that will typically be something that is bundled with a general liability policy and doesn't have necessarily great D&O coverage. Other times associations will, if they really want, the good coverage that's going to cover a lot of issues, would buy a standalone D&O policy, which is what I would typically recommend, and that's going to have a lot more coverage. And so most people, unfortunately, don't find out until there's actually a claim and it's too late to do anything that maybe I should have purchased the expanded coverage. But, certainly, kind of what you want to look at here is what the exceptions are. And so, things like related to crime, employee dishonesty, cybercrime, those typically are going to be excluded and need their own insurance policy. If you have a good insurance policy, it's going to cover defense costs for breach of contract claims, or claims for, I guess, whether or not you purchase the appropriate insurance. Discrimination and fair housing claims, these are definitely on the rise, and I see a lot of people try and use these as vehicles, to settle the score with some other dispute, even if there's not legitimate, but they can be very expensive in defending. And so you want to make sure that you have coverage for that. Same thing that employment practices. With respect to those scenarios that we just went over, a lot of policies will have what they call an insured versus insured exception. And so that means if you have two board members suing each other, that there will be no defense whatsoever for either of them. And so if you have you're looking for the works with respect to the coverage, you want to make sure that you have an insured versus insured exception removed from that, and it's going to cover those claims. And so we've seen that quite a bit, and oftentimes the insurance carrier will have to pay on both sides of the case. But we've also seen where somebody's claiming they're an officer or director or removed, and then they sue the other board members, and there's no coverage for anybody because of the policy. Non-monetary damages as well. If you have a good D&O insurance policy, it's going to cover claims if you're just sued for injunctive relief or claim that somebody is on the board or not on the board. And there's no monetary damages involved. The cheaper policies are typically only going to cover monetary claims, and some of the non-monetary claims can be pretty expensive, to defend. So keep this in mind when you're shopping for D&O insurance, and I'd recommend, checking in with your insurance agent to figure out, whether you have the appropriate coverage or you may need something a little bit better. So I'm going to move into the remaining governing documents here. So we have the master deed, condominium, and corporate bylaws, which you're going to see for condominiums. Corporate bylaws can come in two forms here. Modern trend, make it easy to find, consolidate them with the condominium bylaws. That way you don't lose them, everything's together and it's easy. Technically, they don't have to be that way. The corporate bylaws under the Nonprofit Corporation Act, which typically just deal with governance issues, those could be a separate unrecorded document. But keep in mind that over the years that could be lost. Sometimes I've seen recorded documents reference that and nobody can find it, and things get a little bit sticky in that circumstance. But those are typically going to be the documents you're looking at. For an HOA, you're going to have, like I said, restrictive covenants, deed restrictions, or declarations recorded. And typically the corporate bylaws are going to be unrecorded there that will deal with the governance issues. If you're in a condominium, what you're going to look at in the master deed and kind of the key components of this is, do you have legal description? Does it have the correct number of units in the text that match the condominium subdivision plan? I've had several cases over the years where units may show up in the subdivision plan, but not the text, and vice versa. There's title disputes about whether these units are still in the condominium or not. And so it's kind of important to take a look at that, make sure that that is correct. and fix it if it's not. What the common elements are and who's responsible for them, whether they are limited, assigned to a particular unit or units, whether they're general, and how the responsibilities for maintenance or repair, are they clearly outlined, and how do those shake out? Responsibility for repair is a big one, whether it's the association versus the co-owner. The percentage of values, the Condominium Act requires the percentage of value assigned to each unit to add up to 100%. And then you also have to designate what it's used for. Is that just the undivided ownership interest in the comp elements? Does it apply to voting? Does it apply to assessment payments? Easements, this is another big one that I've seen over the years, whether somebody else has the right, to go through the condominium, whether it's utility, city, developer, that kind of thing. And there's typically going to be an amendment provision. So if you're dealing with a condominium, you got to have 2/3 co-owner approval to amend the documents for any kind of material changes. 2/3 mortgagee approval. There's 9 different things that are going to require that. And for certain things, it may require developer consent depending on how the initial master deed was drafted. For condominium bylaws and covenants, this is typically going to be, I think, where a lot of the enforcement lives. A lot of the rules, a lot of the nuts and bolts, where your job as a board member, is really going to, I guess the rubber's going to hit the road. So typically what you're going to find here is things like architectural control, modification requirements, assessments, insurance requirements, what kind of requirements the association, what kind of insurance they're going to be required to carry, what kind the individual owners are going to be required to carry. Leasing and rentals, I can tell you that one of the most common violations we deal with relates to, rental caps being violated if you have one, people not notifying the association that units are rented, or restrictions related to short-term rental and people using, Airbnb and VPRO. And typically what the requirements for that, those are going to live here as part of the restrictions. Any kind of nuisance smoking smells, whether it's tobacco smoke, marijuana smoke, whether that's going to be permitted or not allowed, and whether people are causing a nuisance or disturbing other people in the community. It's typically you're going to see restrictions on that. Parking, where people can park, what types of vehicles, commercial vehicles, non-commercial vehicles, whether people can have trailers, RVs, that kind of thing. What happens if you park in an incorrect spot, towing. So those are going to be covered. Restrictions on pets or animals are going to be kind of another big thing. And then a lot of the issues most documents don't address, but we're kind of seeing pop up more frequently now, is technology related issues, the use of drones and whether that's permitted and where it's permitted in the community, what you need to do to get an electric vehicle charging station and requirements for that, Wi-Fi use, especially if you have common Wi-Fi use for the condominium at a clubhouse or something like that. Smartphone use at meetings. Are people going to be allowed to be required? Social media use, is certainly another big thing, whether somebody can go on and, use the association's name and create a social media page. And solar panels, I'm going to talk about that a little bit later. But there's actually some legislation that's been proposed this term that could impact the association's ability to regulate solar panels. I see somebody who put in the chat generators, and definitely this is an issue I'm seeing a lot more of, especially with the power outages from DTE, and your policy on whether you're going to have permanent ones need to go through a modification agreement. The association is going to allow temporary ones, or whether you just don't really have room and it's not safe within your community, or it's going to cause issues by installing those. So typically what people are allowed to do, this is where that's going to live with respect to the governing documents and the condominium bylaws, or some form of a restrictive covenant. So we have the rules and regulations here. So I'm going to give you a brief scenario and get some input here from the crowd as to what this looks like. So Electoral Acres Association, the bylaws require the association to maintain, repair, and replace the limited common element front doors. Bylaws also permit the board to adopt rules regarding the appearance of the condo. The board adopts a rule that each co-owner is going to paint their front door brown at their own expense. Matt is difficult and refuses to paint his front door brown like the rest of the owners. Association sues Matt. Who wins in this scenario? Go ahead and turn it over to the chat if anybody has any guesses as to whether the association is correct here or Matt is correct here. So we have HOA, association. Matt is the loser. Okay. So we got a lot of association guesses. So this is actually based on a real case from the Court of Appeals. And the co-owner, so Matt would be the winner here. And the reason is because the bylaws themselves required the association to maintain, repair, and replace the front doors. Even though they were limited common elements, they were still required to do that. So what the court said is by enforcing the owner to pay to paint his own front door at his own expense, that you're really changing the maintenance responsibilities. And you are required to do that through an amendment to the bylaws. So essentially what they did is they tried to enact a rule that ran counter to the bylaws, and the court said that that was not enforceable. So keep in mind that when you're enacting rules, and most documents allow you to enact rules, that you're not altering some sort of existing remedy with respect, or right or obligation or anything that's in the bylaws. What the law says is that you are allowed to implement something that already exists in the documents, but you can't go ahead and use that as a tool for a backdoor amendment. So I guess the other things to kind of look for that, a lot of people come to us for bylaw amendments, or that their documents are outdated, or they end up in litigation. There's pretty significant changes to the Condominium Act in 2000, 2001, 2002. So if your documents predate 2002 and they've never been touched, odds are you're probably going to need a pretty significant update there. So that's something, to keep in mind. Where I see a lot of people kind of get into trouble is they will follow something in the documents. It's no longer consistent with the law. And then they're doing something that's not permitted by the Condominium Act. Developer turnover. So a lot of times the developer will draft the documents for their own purposes. They don't really, I guess, have in mind what's necessary for the long-term operations. They will have a lot of liability protections for themselves and try and reserve different rights for themselves. And you want to, suck those out so you don't have somebody coming along saying they're a successor developer later on and they're entitled to those rights. So if your documents have never been changed since the original developer, it's typically a good time to take a look at them. The technology issues we spoke about, a lot of those we don't see in documents, but it's important to address those to avoid litigation. The other big thing I'll tell you, if your practice and what you're doing differs from the language, that is a huge red flag. And if you want things to be a certain way, I highly recommend you amend your documents so that the documents conform to the practice. Because I see a lot of litigation and fights, sometimes when boards start deviating from what's there and what's in writing. Certainly, if you can't understand your documents or there's provisions that conflict, and I've seen that before, you want to fix that. And if you have no liability protections in there, that's also going to be a red flag. So we have a question here that says, what if the master deed was issued in 2004? Is there a half-life on master deeds? What's the right age for a major overhaul? That's a complicated and expensive process. The best way that I can put this to you is that, pretty much if you're not making any updates, it's really no different than you driving a car without an oil change. And if you aren't performing regular maintenance and, rotating your tires, changing your oil, that kind of thing, eventually it's going to break down. And so, the potential issue there is that, some associations, I mean, they can go for 15 or 20 years and not, have an update and not experience an issue. But a lot of times what I see is then somebody new moves into the community. They're not aware of how the association has been operating. They bought in reliance as to what's recorded there or some sort of statutory provision. And then they can get into trouble that way. So one thing, and I'll talk about a little bit later, there's not necessarily a half-life on master deeds, but we have something that's called a condominium and HOA report card, which is kind of our diagnostic tool. And I'll get into that is to, to kind of tell you where you may have potential issues in documents if you don't know. Let's see. So we have another question. What is the benefit of adding R&R language to a bylaw when the R&R may contradict the actual bylaws? Is doing more the same as doing less? I'm not sure what R&R means here. If you could clarify that, I will try and touch on it. Rules and regulations. Okay. So all right. So I guess as far as the rules and regulations, so typically the rules, I mean, kind of think about it is those are going to be the trees, and where the condominium bylaws is really going to be the forest. Is the best way that I would do that is you're going to lay out, the broad strokes, that you may, have a process, in the documents and say that people have to pay assessments. And it may say that, a lien can be placed and it can be foreclosed on if they don't pay assessments. But the actual kind of details and nitty gritty of that process and setting up, a procedure where, after the first 30 days, it would get, sent to the attorney, then they would get a letter, and then a lien, and then foreclosure, and so on and so forth. That's really what you're going to use the rulemaking process. So that's really to kind of fill in the details of something that's already in the documents, or to clarify that, a little bit further. So that's kind of what we're looking for there on signs for the document amendments. And as I alluded to earlier, for condo and HOA report cards, this is something just because a lot of people are unsure whether they need an update or not. Sometimes it's pretty easy if your documents were drafted in 1992. There's just been a lot of changes in federal law, Fair Housing Act, that kind of thing. It's pretty easy for us to take a look at that and say you're probably going to need a complete rewrite, and to somehow build that into the budget in the future. With respect, to the question, for example, somebody said, my documents from 2004, how do I know if they need to be updated? And so that's kind of where the report card comes into place, is that we'll go through all your documents, check boxes, yes or no. Do you meet these legal requirements and best practices? If you're on our premium service plan, we offer a discount for that. It's typically going to range, from $1,000 to $2,000. To get that done. And then the other key thing here is that we try and break this down in layman's terms to make sure that you understand it. I'm kind of a firm believer that I see a lot of these documents we get from developers, attorneys. They are drafted by lawyers for lawyers. And so, I mean, we have meetings in our office and we really try and break this down to remove the legalese to the extent possible. Because I think it's really important that you have a user-friendly set of documents that you guys can understand. So that's the documents. With respect to moving on to the meetings here, this is going to give you a few kind of tips as to what you need for board meetings and association meetings. So every year you are legally required to have an annual meeting. If you do not have an annual meeting in the last 15 months, a member or somebody can sue and ask the court to order a meeting. When you hold the annual meeting, you have to first decide, who is going to be eligible. And you do that based on a notice. So everybody has to get notice. It has to be written notice unless you have some form of a consent or somebody has opted into receiving electronic notice. So you have to mail those notices out. Some associations, most people have opted into the email notice, and that suffices. As long as you mail it out, that doesn't mean that you can't also just go ahead and post it online or email it, but the official notice, it has to be mailed unless somebody has consented to that. For eligibility requirements, that's the other big thing, is determining who is eligible to vote. And you do that for the record based on the record date. And so if you can set a record date as a board, and so you vote on that and put in meeting minutes as to, when somebody is current, for example, if the documents say if you're delinquent on your dues, and you can't vote, and you as the board can decide when you want to accept those dues, and that person would be eligible to vote. If you don't make that decision, the Nonprofit Corporation Act provides a default, and that basically says it's the day preceding the notice that was sent out. So a lot of times I'll go to these meetings and the board does not, change the record date. technically speaking, and this could make a difference if it was a close election, if somebody shows up to the meeting and says, here's my check for delinquent assessments, I want to be able to vote, you're supposed to, say, thank you very much, take the check, clear out, their balance to a zero ledger, but they were not eligible to vote as of the record date. So keep that in mind. They have to be eligible to vote as to that particular date. The other thing I've seen here, and just to be careful of, is that you're really electing directors at the annual meeting. It's very rare that I've ever seen documents say membership is going to elect the officers. So the directors are really going to be the ones who are going to vote. Oftentimes, most boards have 3, 5, 7, an odd number, and then it's your first meeting of directors for who gets elected there. That's when you're going to elect the officers. But making sure that the board is still voting on everything, and you follow up as to the officer positions, what their assignments are, because those are usually spelled out in the bylaws. When you are at board meetings, the key components that you're going to do is architectural approval, budgets, contracts, electing officers, enforcing restrictions, making sure that you're voting on these. And then for the meeting minutes, basically, making sure that you keep a record of that. And that's going to be important. The Nonprofit Act requires you to keep a record. You don't have to essentially write a book for every meeting, but you do need to indicate that we voted, this was the decision, and this was the result of the vote. You don't need to include everybody's discussion and everything that went for that. But it's important to keep a record, especially if you're voting to impose fines or anything like that, somebody will be able to come back and take a look at that. Or for architectural approval, that 10 years down the line, if somebody comes along, and there's a question as to whether the association approved this or not, you have a good record of that. So make sure you're taking meeting minutes. They don't need to be a novel, but, at the very least, document the decisions that you're making. So we did have a question. It says, for many years, we have delivered the notice to each unit in open mailbox slots. This year, we wanted to use both email and hand delivery. Is this okay, or do we have to use regular mailings? This typically, I guess, depends on the language of the documents. Most documents will require it to be mailed. If it says hand delivery is okay and it gets there, that will work. The bylaws are allowed to prescribe the form of notice. And certainly emailing in addition to a permitted notice is okay and is going to help you get more people to the meeting and actually hear about it. We have a question here. Does architectural approval have to be approved by the board? So that also depends on the language of the documents. Some documents require pretty much everything. Some, depending on how your community is configured. If you're in a site condominium, it may just be the exterior of the building you have to get certain approvals for, nothing on the interior. Attached condominiums may require pretty much anything. Generally speaking, if you have any kind of modification or change that's going to tie into common elements in an attached condominium, you're going to have to get board approval for that. And so I guess exactly what you're approving is important to vote on and keep a record of that. Because we have had a fair amount of cases where people have put in different things than were actually approved. And so that's important to keep a good, clear record of that. Let's see, we have a question here about how can a board update its antiquated bylaws when it can't even ever get quorum to do so? Even more so, can't enforce violations because the bylaws have no fine structure enforcement provisions. So the answer to these couple questions here is if you have old bylaws, you typically are going to want to start with amending the articles of incorporation first. And the reason being is in most cases, unless you have a specific amendment provision, the threshold to actually amend those is going to be lower. And typically you just need, quorum at a meeting. And so, if you have trouble doing that, if you have an action without a meeting provision, which we prefer, and that's in the documents, you can do a ballot voting process. And collect ballots over a certain period of time. And we typically, recommend if you have that provision already, kick that off in conjunction with the meeting and then kind of go door to door, divide up the list of the owners to make sure everybody's voted, send them emails, that kind of thing, is what we found to be effective. And with respect to enforcing bylaws, for fines, they can be effective for certain things. If somebody leaves out their garbage can or, things of that nature. For bigger things, they're generally not going to be an effective remedy as far as, short-term rentals, somebody parking, commercial vehicles, things of that nature. And so in most cases, you're going to have to go to court and get an injunction unless they voluntarily stop. All right, moving on. I'm gonna ask some questions here related to the different types of meetings. So this is related to a board meeting. Joe wants Electoral Acres Board to approve a contract to install solar panels to reduce the association's energy costs and make up for his insurance gaffe. Joe wants to act quickly and proposes the following options. They can conduct the vote via email. They can hold a board meeting via Zoom, even though the bylaws are silent on Zoom meetings. Or they can provide Joe with proxies to vote in an in-person board meeting if any other board members are unable to attend. Are any of these viable options? So I guess I'm going to open it up to the audience here and see if you think any of these would work for holding a vote, and I'll kind of let you know what's allowed and what's not allowed. So see, we have one person who says none of these options are. We have another that says all three work. Any other guesses? Question marks? No, just option 3. So I'll kind of walk through these one by one. So for voting via email, that is going to work as long as you have unanimous consent. And what the nonprofit action says is you can take those votes, you can attach them to the next meeting minutes, and that would count as long as it's unanimous. If there's disagreement on it, that's not going to work. Or if everybody doesn't vote, it's also not going to work. Hold a board meeting via Zoom, even though the bylaws are silent on Zoom meetings. As long as there's nothing prohibiting this or requiring an in-person meeting, this is okay under the Nonprofit Corporation Act. The key here is you have to make sure, whether it's Zoom, some sort of telephone conference, Teams, whatever it is, that there's two-way communication.
I forgot about this.
And everybody can participate that way. Then the third one is to provide Joe with proxies to vote in an in-person board meeting if any other board members are unable to attend. And so that is not an option. So proxies are only available to be used and at meetings of the membership. These are not available to be used at meetings of the board. So please keep that in mind when you're conducting your board meetings. All right, so moving on to enforcement here. So the different remedies available is the question I just fielded is fines. So those work for certain things like leaving out your garbage cans. Liens for collection. You can sue somebody for monetary damages. You can sue somebody for injunctive relief to get them to do something or to stop doing something. Recovery of attorney's fees. And so that's going to be driven by your documents, but most documents allow for the association to recover attorney's fees for a violation of the bylaws. You want to make sure that you have a clear bylaw enforcement and collection policy, as I talked about as part of your rules, so everybody's on the same page and treated equally as far as the steps they go through when there's some form of violation. So I'm going to hit on fines here real quick. And this is important for condos. It says Hunter is an investor that owns 10 condo units in electoral acres. The bylaws prohibit rentals for less than 6 months. Hunter rents his units on Airbnb on a weekly basis. Joe instructs the property manager to fine Hunter $100 for each violation per the bylaws. Hunter does not pay the fine. The association places a lien for the unpaid fines as the bylaws permit automatic fines. Hunter sues to have the lien removed. Who wins? So in this scenario, go ahead and put in the chat how many people think the association wins and how many people think Hunter wins here. Okay, Airbnb wins. Hope the HOA, association. So in this one, one sort of misstep that I see that a lot of associations make is for fines. You have to have notice in a hearing under the Condo Act. So in this one, Hunter's probably going to win because they just tried to do an automatic fine and have the manager ship this out. You have to give notice of the violation, and then typically for the hearing, you invite the person to a board meeting. If they don't show up, you can vote to impose the fine. And there's just has to be that due process component. We had a case, it's been up to the Court of Appeals several times, involved a situation where the board imposed fines, somebody hadn't completed a house. And really what the court looked at there was the correct process followed. And so we have a question that says, what if it says no Airbnbs in the bylaws? So the answer to that is going to be that you can impose a fine if your documents permit fines and you follow the appropriate procedure. In my experience, though, for short-term rentals and Airbnb, fines are not a good remedy. Most people will just pay the fine and keep renting or building that into their costs to rent, so that rarely solves the problem. Typically, what I see in those situations, and we've had a lot of litigation in recent years, is that you have to file a claim in court and get an injunction and get the court order to get the person to stop renting, because a lot of times they will gladly pay the fine and it doesn't solve the issue. All right, so for collections, another scenario here, a hunter is upset about rental restrictions and stops paying assessments. What remedies are available to the association to collect assessments? So we have foreclosure by advertisement, judicial foreclosure, eviction, rent diversion. So anybody maybe want to put some of these options in here as to how we can get somebody to pay in Michigan? Any ideas on this one? All right, somebody says that they want Tony to be their enforcer here. Eviction. So on this one, I would say the most common way that we collect assessments is through foreclosure by advertisement. So Michigan allows foreclosure by advertisement and judicial foreclosure. And typically what the process is, somebody will get a letter. If they don't pay, they will get a lien. If they don't pay after getting a lien on the property, then we'll do a foreclosure by advertisement. That typically is going to be 6 to 9 months faster than if you try and do a judicial foreclosure. You can go to court, you can sue somebody for a money judgment. In our experience, it's usually just not, as efficient as doing a foreclosure by advertisement. So eviction, so you can only evict a tenant in Michigan. You can't evict an owner. In Illinois, for example, you can evict an owner, and that's their primary vehicle because it's allowed by their statute, and they don't have foreclosure by advertisement. But eviction in Michigan, our statute only allows for you to evict a tenant, not an owner. So that may work depending on what you're trying to do. And rent diversion is also an option. So if you have somebody who is a tenant, what the Condo Act says is you could send them a letter and suck that rent payment to you to pay towards assessments. If you have somebody who is not current on their assessments and they have a tenant in their unit. So those are the primary vehicles related to collections. I'm going to kind of go over a few bylaw enforcement issues here and injunctions. So we have the condo bylaws require board approval to alter the common elements. Hunter places a hot tub on his limited common element deck. He hires an electrician to install a dedicated box to power the hot tub and general common element wall. The bylaws are silent on whether hot tubs are allowed. Electoral Acres sues Hunter and seeks an injunction to remove the hot tub. Question here, and this is modeled after a real case we had here in Michigan, is does Hunter get to keep the hot tub in this situation? So take a look at the chat, and anybody want to let me know if they think the association wins this one or Hunter wins this one? So in this circumstance, Hunter did not get prior approval. All right, so it looks like we have Hunter loses, he can't keep it. No ACC approval. So it looks like the audience has got this one right. So kind of the key thing that they looked at here is that there was a limited common element. Yes, a powerless hot tub would be okay. So Mark is correct on that one. In that, he may not have necessarily needed, I guess, approval to put the hot tub on his limited common element deck, because he was allowed to do that in that particular area. But where the court indicated that there was an issue is that he made a modification when he actually went into the wall, the general common element wall, tied into the electric system there in order to power the hot tub. Was where he really needed to get that approval, is how this case shook out. So what ended up happening is the association sued, said that he had to remove it, and the court ordered an injunction and required him to remove the hot tub and the modification that he made without the appropriate authority. All right, so money damages, is certainly a remedy to enforce the documents. So we have Hunter, his short-term rental business was unsuccessful under the condominium documents. So he decided he wants to go into the recreational marijuana business instead. The condo bylaws prohibit illegal activity, but Michigan has decriminalized marijuana. Hunter plugs in his grow lights into the common element hallway, decides he's going to save some money. I've seen this a few times before. Association's bill next time is up 10 grand. And so the questions here are, can Hunter grow his marijuana? Can the association recover the $10,000? All right. Any guesses on this one? All right. Can't use the common elements. Is he running a business? Absolutely not to grow. All right. So a couple things on this one, because we typically get a lot of questions, about marijuana. So certainly he's not entitled to use the general common elements. He can't plug in there. Most documents are going to have a provision that's going to allow you to just assess those costs back to the unit owner. And if they don't pay them, you can certainly recover money damages or sue them to that. Ideally, if you can assess it back to them and put it on their account, then you'll be looking at a collection as opposed to just suing them to recover that. And we'll have the foreclosure remedies that we just talked about in collections. With respect to growing marijuana, so it's a little bit of a complicated issue, but keep in mind, marijuana is still illegal under federal law. And so in most instances, you can still enforce that as a violation of the illegal activity provision. Most documents don't get specific enough where they say that it's only something that's going to be illegal under state law, local law, any of that kind of thing. The person who talked about the business aspect of this, that could certainly be used to probably shut this down in a marijuana grow operation, as well. And so, most documents are going to have some sort of residential use restriction and not commercial use. So certainly either of those would be avenues. But actually, to get somebody to stop growing marijuana in their unit, you're typically going to have to pursue an injunction, and they're going to make more money selling the pot than they are, enough to pay fines if you decide that you want to go that route. So keep that in mind. So Hirzel's hurtful mistakes. So we're going to get through these 5 quick scenarios, and then I'll open it up for kind of questions if anybody wants to talk about anything that we have here discussed today or anything else. So quorum. So this is kind of an issue I see that some associations kind of go the wrong way on. And so we have electoral acres. They have 100 units. Bylaw state quorum is 50% of the co-owners in good standing. All co-owners are in good standing. 48 people show up to the meeting. The association proceeds with the meeting. Donald Bump Jr., Ivana Fair Election are elected to the board at the meeting by a razor-thin margin. Joe Susan says the meeting was invalid. Will the court order a new election? And then the question is, and I've seen this happen several times before, is that somebody will make a motion to waive quorum. So you just go ahead and put in a chat, but anybody have any ideas as to whether we're going to get a new election here and whether you can make a motion to waive quorum? So looks like yes, new election is required. Any other thoughts on this one? So no waiver. So correct answer from the audience again here. So you can't do anything in a meeting without quorum. You can't make a motion to waive quorum. A lot of times we'll put into our documents, and we see a fair amount of documents that you can have a reducing quorum requirement. So it says that quorum may be 50%. But if you don't get quorum the next time that you get together, it's 25 or it reduces by half. So I'd recommend doing that. But certainly any kind of action that's taken when you don't have quorum is not going to be valid and it can't be waived. So keep that in mind when you're having your association meetings. Audits and reviews. So we have Donald Bump. He's concerned that Joe is mismanaging the association's finances. He demands the association perform an audit. The board determines an audit would cost $4,000 a year, and an audit is not required by the condo bylaws. They obtain a compilation for $500 instead of an audit and send it to the owners. Donald sues the association for an audit. Who wins? Any thoughts on this one? Association wins, okay. Association. Okay. So in this one, it's all going to come down to how much money that the association has. So if you have $20,000 more in annual revenue, the Condominium Act requires you to get an audit or a review. So an audit it's going to be performed by a CPA. It's going to be more expensive. It's really going to be a deep dive. And they're going to go check receipts and everything like that, and give you an opinion on the association's financials. A review is also permitted, and so that's not going to be quite as deep of a dive. But the auditor, the CPA, they're going to take a look at some of the basic association documents. They're still going to give you an opinion, and take a look and make sure that all the numbers seem to make sense and jive, but on a little bit higher level. Compilation does not satisfy this requirement. So a compilation is essentially somebody saying, put these numbers into a financial statement and pass that out to the owners. So every year an association is required to distribute a financial statement to the owners. It typically happens at the annual meeting. But keep that in mind. The only way, if you have more than $20,000 in revenue, that you're getting out of an audit or review is if you actually have a vote of the owners to opt out of that on an annual basis. Otherwise, it's going to be legally required. So if the association more than $20,000 in revenue, Donald is going to win this one. All right, record inspections. So this is always a fun one. So we have Donald Bump. He wants a full investigation into the association's expenditures. Claims that the board meeting minutes will demonstrate that Joe forgot to pay the insurance bill in 2022. Donald attends the next board meeting and demands the board email copies for every insurance bill for the last 10 years within 5 business days. Donald claims the Nonprofit Corporation Act allows him to access all books and records of the association. Does the board have to produce these records? Take a look at the chat and see if anybody has any ideas on whether he's got to get these or not. So we have a yes. Yes. So not all of them. Okay. So the answer to this one, it's any owner can see the records upon request. So the answer to this one is what the Nonprofit Corporation Act says, is that you can inspect the records. The only records you're actually entitled to say that somebody would have to send you is going to be the financial statements. But he's just looking for board meeting minutes here. And so he would, under the Nonprofit Corporation Act, would have to identify a proper purpose. He could then go in and inspect those. There's no requirement that they necessarily be mailed out. And then the association will be able to charge him, costs for reproduction related to that. So, generally speaking, I find that, transparency, really helps in operating an association. It builds trust amongst the members. Occasionally we've had several lawsuits and people, they just, ask for 10 years and thousands of pages of information, which isn't possible. But to the extent somebody is not making abusive requests, it's typically easier to cooperate. But certainly if somebody is making life difficult for no reason, just trying to harass the board, you can certainly insist on the statutory requirements being complied with. Fannie Mae, Freddie Mac approval. So this one is something that's been a little bit of a hot button issue since Surfside, and actually at the end of September, some new requirements went into effect for lending guidelines. But Electoral Acres is an attached condo. It has 100 units. 20% of the units are delinquent 60 plus days. Reserve fund is only 5% of the annual budget. Board has never had a reserve study. The roof leaks on the entire top floor. AC for the entire building has stopped working. Board decides to build the repairs into the budget for next year, though. So they're going to fix these. Will Fannie Mae, Freddie Mac purchase mortgages in this condominium? So we have one person says no, many rules violated. Any other thoughts on this one? No. So the audience is correct. There's definitely a lot of issues here. The underwriting guidelines, to some extent, what every underwriter is going to vary from each mortgage company, which makes life a little bit difficult. Most of them try and comply with the Fannie Mae and Freddie Mac guidelines because they want to resell their mortgages to Fannie Mae and Freddie Mac. But typically what a lot of associations are shooting for is you want to have delinquencies at a rate of 10% or less for 60 plus days. Reserve fund, we have a statutory requirement. It's going to be a minimum of 10% on a non-cumulative basis, but they're looking at for 10% from Fannie Mae or Freddie Mac as well. And really the thing that's kind of new that they're starting to delve into is the condition of the building. And so if you have what they call critical repairs or you have major structural issues, that they may deny loans or they may not loan in your community based on that. I haven't seen, there's been a lot of talk about a blacklist. And there's a lot of other requirements that have to be satisfied, and it could relate to the number of rentals in a community, developer-owned units, things like that. And so I haven't seen a lot of associations, I guess, go on that blacklist or get flagged. But I know that the requirements have tightened in the last couple of years. And so to the extent that you can, try and keep your association in compliance with these underwriting guidelines, a lot of the co-owners are going to be appreciative of that, and it will make it easier to sell units in the project. All right, so the last scenario we're going to talk about here real quick is fair housing. So we have electoral acres. They have a basketball court and has recently had problems with nets being cut down. Board suspects teenagers of wrongdoing. Board adopts rules requiring any minor under the age of 16 be accompanied by a parent when using the basketball court. Matt complains the rule discriminates against families. Is he correct here? So is the question, is this rule going to be acceptable, or is it something that may get struck down by the Fair Housing Act? Any guesses on this one? So on this one, this is another thing I see a lot of things that may be common sense, but there's a lot of federal cases out there that talk about familial discrimination. And essentially they say that, rules like this, if minors have to be accompanied by a parent, they may violate the Fair Housing Act because they discriminate against families by requiring everybody in that household, to be present. A lot of times I'll see these for pool rules, and it may be in a context of trying to be safe related to swimming, but you kind of have to gauge those in terms of the ability, to swim laps, for example, or the ability to swim safely, as opposed to arbitrary age requirements. There's cases out there that have said, a 16-year-old could swim better than, an 80-year-old, for example, and so on and so forth. So just be careful that, maybe you have vandalism or something in your community with these types of rules, as I've seen a rise in claims for them, in recent years and cases coming out about this. So if you get any other, I guess, sticky issues that involve race, religion, sex, gender, any of those kinds of things, they're highly fact specific, and they're potentially, significant penalties under the Fair Housing Act. So yes, I like Tom's suggestion there, use a chain net instead, so that then you don't need the rules. But anyways, that's kind of the basics, what I had for you. A lot of this came from Hirzel's handbook. It's available on Amazon. So we recently put out the second edition. But I like to tell people that this will pretty much get you, 80% of the way of where you need to go. And is an easy reference guide. And then typically we're here to help you out with, all of the really hard stuff, or if you get in a pinch, and need some advice. So that will also kind of help you, learn the basics of what you need to know. Wanted to point that out, and I'll go ahead and take down the, I appreciate the kudos on the book. So it looks like we have a few readers here. But I'll go ahead and feel free to unmute yourself. And if you have any questions about any of the scenarios, presentations, or anything else that you're encountering, I will do my best to go ahead and answer those for you.
I've just stated.
So we did, let's see, we have a question here in the chat. How much do you charge for Laura and the new Corporate Transparency Act? So right now, Laura is something we just charge at the hourly rates, but I'd say on average that takes about, maybe a half hour's worth of time. The Corporate Transparency Act is going to be a little bit more involved, and we're going to have to gather quite a bit of information from each of the individual board members securely in enough, like I said, in a format where they probably don't want to be sharing their passports or licenses and the like with each other. So that one for the initial filing, it's a $500 flat fee for the year to get that done is what we're going to be rolling out next year. And then it will be half that for any kind of updates that we would have to file to indicate any changes on the board.
Can you go into some more detail on this federal law change that is going to take place next year? How will we be notified and so forth?
So I don't think you will be notified about it. Basically what this is that every corporate entity in the United States is required to do that. And the rationale behind this is that they're trying to combat terrorism and I think foreign investment, in the United States. And so, this is not, I don't think condominiums are necessarily a hotbed for this activity. But they are not exempt from the statute. And so essentially when you have the Nonprofit Corporation Act or nonprofit corporation, how these are organized, it's a little bit different than a for-profit corporation where you have shareholders and in particular owners, and it's pretty easy to identify where money is flowing and not flowing. But since there's no exemption here, basically, you have to identify who's in control of this organization and who has the decision-making authority. And that's really what they're looking for. And so, as I indicated on the slide, you have to provide basic information, in an EIN for the association itself, but kind of the biggies that I think is going to cause some consternation for board members, in addition to the name, address, contact information, is providing that unique identifying number, as well as a copy of that document, to the federal government. And they, I think, really want to have, especially if there's some sort of, financial crimes, is really what FinCEN is trying to track here. My other kind of inclination on this is that this is one of the smallest federal organizations or agencies that exists. They do not have a very big budget. It kind of remains to be seen how enforcement is going to work. I highly doubt that they're going to be running around trying to put board members in jail for this. I could see a world though where they try and fine people the $500 a day to increase their revenues. So this is not something that's targeted just towards community associations. They kind of get, swept up into the bunch. But this is also not going to be like Laura, where they send you a bunch of reminders and say, the taps on the shoulder and you only have to pay a $5 late fee, with a penalty of $500 a day up to $10,000. If they wanted to use this as a money-making opportunity, like I said, I wouldn't want to be the test case for this. And so it's easier to comply and do the right thing and make sure that's part of your annual routine.
So going one step further, do you think they'll link that to the IRS?
That I don't know, but I wouldn't be surprised. In my experience, I mean, I'm not an expert on federal government, but interestingly, a lot of these agencies kind of stay in their own lane and enforce what they're going to enforce. But I could certainly see that if there was some sort of crime that the IRS would go to them, or they may refer something, to the IRS or gather that information about who's really the owner of these entities and trying to get into, shell corporations and figuring out where money is flowing. Like I said, I don't think they're probably going to catch a lot for condominium associations. But based on, the state of the law, it is something that board members and associations are going to have to deal with and file those reports. The good news is since this is the first year that's rolling out, starting in 2024, you have till the end of the year to file that and comply. And that's for existing entities. For any kind of new entities, originally you're going to have to file it within the first 30 days. But they've rolled that back to an October deadline, for new corporate entities as well. So, what we're going to be sending out, for us, spending a lot of time next year, and, I have a blog article that's almost done and sending that out to our clients. So I guess we're going to be the ones who are trying to kind of drive the reminders on this, to make sure that everybody complies, whether that's, on their own and they're comfortable submitting that information, or they kind of want to use us as the source because we already have to keep, information confidential and the attorney-client privilege, and make sure that we have a secure procedure so everybody feels comfortable that not just, shooting this out and doesn't know how the management company is storing it or sharing it with, or how their fellow board members may not want to see that either.
So those of us that are dealing with you can expect some sort of notification as this rolls along.
Yeah, you'll get multiple notifications
Good.
as this rolls along, and reminders, because we don't want to see any of our clients get hit with this. And so, probably at least on a quarterly basis, up and through the end of next year. I would ask though, hopefully people don't wait until, December 30th of next year to try and do this, because to some extent, if we get 500 of these on the last day, we may not be able to get to all of them. So I'd encourage you to try and do it probably sooner rather than later, so you can check it off your list and not have to worry about it. So.
And that'll be $500 for all board members?
Yeah, we would take care of the filing for the association, gather all the board member information, securely, save that and then upload it, in a fashion so you don't necessarily have to share that with everybody else on the board if you don't want to. Because I kind of assumed that was going to be a pain point, that people, not all board members always get along, or they may be worried that somebody may take that information and do something with it. So we wanted to make sure that there was a secure way that you could submit that to us without having to share that with everybody.
Sure.
What if the board member decides they want to submit it themselves? Do they have to go through anyone, or can they go directly to the federal gov website?
No, there has to be a single filing, so all the information has to be submitted together. So if you as the board decide that you want to take care of this yourself and you guys are willing to share that information with each other, you certainly do that. And that would meet the requirements, but it wouldn't be that like 3 board members come to us and then one person kind of on their own type of thing, because all the information has to be submitted together.
No, what I'm asking is, what if a board member says, give me the web page, I'll submit my own? Can they go directly to a .gov site and do it?
So the system they have, it's going to be called the BOSS system, and it's not completely rolled out yet. My understanding, at least everything I've heard, is there has to be a single submission for the entity, and then it has to be uploaded. I don't think you will have the ability, the way it's been described to me, that, all 5 people could go in and submit something separate, and then they would all tie that to the same entity. I think what they're really looking for is all the information for a particular entity to be bundled together and submitted. But I won't know that for sure until they have that finalized and can go in and take a look at it starting next year.
And you made mention of they want to know who the owners are. And that's part of what this is. In an association, all of the homeowners are owners. So it could be 200 homeowners who are owners in this association. How does that work?
And what they're really looking for is who has the decision-making authority. And so, typically in a for-profit corporation, they're kind of look at what they describe as the beneficial owner. And so, in the context of a nonprofit corporation, I mean, if a developer would still own, have a seat on the board, they're still going to have to make disclosures. When they have the association, they're going to be responsible for making these disclosures. up until the point that it gets turned over. When they still are on the board up until they get to the point where they have less than 10% of the units, then it will just be, an individual disclosure. But the way they've basically defined this is extremely broad. And so really they are kind of looking for the owners and who has decision-making authority, but they say, if somebody doesn't have more than 20%, they're looking at who has decision-making authority on behalf of that entity, which is going to be the board.
Okay.
And then our annual meeting is in June, so that's when we're going to elect new board, directors, and then officers from there. So that means we would have to update that.
Or just do it then.
Yeah, so I would say, you can wait until June and then do the paperwork then. But the difference between this statute and what they're going to be asking for in Lara, so on the state level under Lara, you just file this report once a year and you don't have to report real-time changes unless you want to change the resident agent or something like that. This, they want to know who's in charge of the corporation basically at all times. So you are going to, if there are changes, even if somebody just resigns from the board, you're going to have to submit some kind of an update to let them know that information. Or if there's a new board member, let's say somebody resigns and somebody else gets appointed during the course of the year before your next annual meeting, that's an update that will need to be made in order to comply with the statute as well. So, one of the things that will be interesting, to see is how strictly they enforce this and take action to enforce this. But like I said, I'm not super concerned that they're going to use this as a vehicle to send board members to jail. But finding people $500 a day to make some more money for their agency, obviously I could see that as a possibility, happening. So we have a few other questions here in the chat. It says, where in the bylaws do you usually find an action without meeting? So typically you're going to find that in the articles of incorporation. And then on the bylaws side of it, I typically, it's often in both sections, but you're going to have a section related to, it's typically entitled meetings. And so you're going to find it there, and it would say, it's typically towards the end, and it said you can take an action without a meeting. Let's see. Do we have any other questions here that anybody wants to ask?
I have one. Earlier,
Sure.
Someone alluded to the fact that they had a difficult time assembling a quorum for a meeting. We're
Sure.
a very, very small association. We're a total of only 11 units. And most of the time, I really have trouble having anybody agree to attend the annual meeting. What happens if we don't have a quorum? How do we elect directors if we don't have a quorum at the annual meeting? Can we go out on an email basis? Typically, I find people will respond to email, but they just don't want to show up at a meeting.
Sure. Well, a couple things. So if you don't have quorum, then the directors continue on. Under most documents, if somebody resigns, for example, then the board has the authority to appoint to fill that vacancy. So generally speaking, that's how that's going to work. In your circumstance, if people are pretty responsive to email, I'd recommend that you try and get them to email you a proxy beforehand, and you can use the proxies to vote, as quorum. Some documents will permit you to collect ballots, before the meeting as well, and count that towards quorum or towards the vote. So that certainly would be an option as well. So.
Thank you.
So we do have a question here. So changing subjects a bit, someone from your office used to have a monthly meeting with board members or presidents to go over and ask questions. Are you not doing that anymore? So we still do, if you're on our premium service plan, we do have that monthly hotline call. If you're not on the plan and you haven't signed up for it, then you wouldn't be eligible for the call. But I guess for the person that asked, feel free to shoot us an email. If you'd like to participate and get on that, we can certainly add you to the list if you're on the plan or you'd like to sign up for that. Next question is, we have an annual meeting. Can you do a verbal vote to approve the budget? Or must it be a written ballot? So it's pretty rare that a set of documents were to require a vote of the owners as opposed to a vote of the board to approve a budget. I would recommend that if you have an owner approval requirement, you try to amend your documents. I can tell you some of the messiest litigation I've been involved in my career. It's centered around an association that had this membership approval requirement, and they could never get quorum. They couldn't get enough people there to vote to approve the budget. And so what ended up happening is some people just stopped paying because they said, well, the ownership never approved this budget. And so then a lot of things and repairs, they kind of, the wheels fell off the machine, and it ended up in a lot of litigation. And overall, it just wasn't good for the association. And they spent a lot of money unnecessarily. Typically the board's going to have authority to do that, and to vote on that. And my recommendation is that in most documents are set up is that the board is going to be the one that sets the budget and approves that budget. So the question is, where do you find an owner approval or not in the bylaws? So it's typically like if you're in a condominium and have a standard set of documents, you're going to take a look at, Article 2 that's going to talk about the assessments. Most times it's going to say that the board is to create a budget, and then the assessments are determined based on that budget. Any other questions before we get out of here for the night?
I did want to make sure that I understood one thing that you said earlier. If I don't
Sure.
have a quorum, then if the directors agree to another term, they're automatically reappointed.
So it's not that they agree. It's if you don't have quorum, they automatically, their terms get extended. They continue on in that position.
Good.
So
That's
the
what
only
I
way,
thought I heard you say.
and so they can certainly resign if they want to, but you wouldn't just, for example, if you didn't have quorum and you had a vote and just say, well, these people got the most votes, and even if there's not quorum, technically those people couldn't be seated on the board unless the existing directors resigned and the other directors appointed them to fill those seats at a board meeting.
Okay.
Any other questions here for the evening? All right. I'd like to thank everybody for joining, and hopefully I gave you the nuts and bolts and basics as to what you needed. And feel free to tune in. I think our next seminar is going to be on I guess fair housing, and so that's an important topic. So anyways, we'll go from there. And I appreciate everybody for coming out tonight.
Thank you very much.
All right, thanks.
Thanks.
Thank you, very informative.
You're welcome.
Thanks, Kevin.
Yeah, you bet.
Appreciate these seminars a lot.
You bet.